Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondac webinar in association with Forensic Risk Alliance, which will focus on the rise of investigations in the US. We're joined by a wonderful panel today, but before I hand over, a housekeeping item. You are able to submit questions to our presenters by typing them into the toolbar on the right-hand side of your page. You can send in questions at any time, and we will endeavour to answer as many as possible during our Q&A. If we don't have time to get to your question, the panel will be in touch, but we do encourage you to get in touch with the panel too. It's now my pleasure to hand you over to Neil to begin. Thank you.
Great, thank you very much, Dan, and good afternoon, good evening to everyone joining us. I know we've got a pretty global audience today, which is great. I'm Neil Keenan. I'm a partner at FRA in our Washington, DC practice, co-lead of our investigations group. I'm basically involved in conducting investigations, compliance reviews, and assisting on corporate monitorships around the world. I'm delighted to have a great panel today. I'll let them both introduce themselves, but a great background of prior enforcement agencies with Camilla and Nick. So Camilla, maybe you could introduce yourself.
Sure, thanks very much, Neil, and I'm delighted to be able to join you this afternoon as it is here in London. So I'm a partner at Simmons & Simmons. I sit in the International Crime and Investigations group based here in London. I joined about 2 years ago from the UK Serious Fraud Office. I was at the UK Serious Fraud Office for about 6 years, and I held one of their senior management roles as co-head of fraud and corruption, working on some of their most high profile and complex cases. In particular, I worked on the Airbus case, which settled in January 2020, and I think is recognised as being one of the leading examples of multi-jurisdictional enforcement ending in a global DPA and a penalty of, I think, something like 3.6 billion euros, still the largest enforcement penalty for corruption. Now at Simmons, I advise on the full range of financial crime advisory work for corporates and individuals, anything from AML, ESG and compliance risks to internal investigations, and those with the sharp end of an enforcement angle. And my team and I were involved most recently in representing Petrofac Limited in relation to the bribery and corruption charges and the plea deal that they settled with the SFO back in October of last year.
Okay, I'll go next. Thank you very much, Neil and Camilla and Mondac and FRA for having me participate today. It's great to be on with everybody. My name is Nick Borton. I am the head of the Criminal Defense and Investigations Group at Sullivan & Cromwell. I'm based in New York. I started my career at Sullivan & Cromwell, left for a few years. I was working at the U.S. Attorney's Office in the Eastern District of New York as a federal prosecutor. I came back to Sullivan & Cromwell about 17 years ago and have been working primarily in the field of white-collar and regulatory investigations and internal investigations. Represent clients around the world, a lot of large financial institutions, energy and mining companies, and other international corporates with regulatory or criminal issues in the United States. Also individuals. The most recent things I worked on, I was one of the lead lawyers representing Goldman Sachs in resolving its 1MDB corruption investigation. And more recently represented FCA Automobiles in connection with a couple of criminal resolutions in the United States, one involving corruption in unions, and more recently one involving diesel emissions. And so that's me. I'll do all manner of investigations, including sanctions, money laundering, securities, fraud, accounting, you name it. We have a pretty broad practice at S&C.
Yeah, thank you very much, Camilla and Nick. And Nick's too modest, but his work on 1MDB got him the Investigator of the Year award by GIR last year. So a great panelist. So maybe we'll just jump in. The first topic we want to talk about just now is really just emerging global trends. What have we been seeing? And Nick, maybe I can start with you. Obviously, the US had quite a lot of disruption, both obviously for COVID, like everybody else, but also a new administration coming in. What are you kind of seeing from the US point of view in terms of enforcement actions being taken?
Yeah, so look, we are now, a year and a half at least into the Biden administration. There has been a lot of very aggressive pronouncements. There have been a return to certain, policies that were active under the Obama administration that the Trump administration moved away from, and we can maybe talk about some of those later. I think what we're seeing is a definite increase in the levels of activity in the United States, but it has not been a dramatic spike. I think the Department of Justice, I think, contrary to maybe to some perceptions, was very active under the Trump administration, but it was a different kind of activity. It tended to be very aggressive and very focused on particular cases. And what we saw fall off a bit were the sort of industry-wide sweeps that had become very common under the Obama administration and before that, frankly. We're starting to see that come back where, an issue arises in some market and federal agencies, are subpoenaing all of the players in that market, which, really creates, I think, a lot of demand for white-collar lawyers. The other thing, you mentioned COVID, Neil. During the sort of worst of the COVID lockdown, the U.S. prosecutorial and regulatory agencies, including DOJ, the SEC, and others, did a really good job of continuing to push the cases that were already in the pipeline. And we saw a lot of major resolutions, including 1MDB and many others, that were, achieved even, over Zoom, including, Zoom court proceedings. I think what was much harder for the government was to start new investigations. So I think with the sort of, as COVID, slowly ebbs, although it doesn't feel that way these days in New York City. But as courts and offices are coming back to life, I think the pipeline has largely been cleared out. And so I think the lag that we're seeing with the new administration is that it's taking some time to initiate new major investigations. I think doing that over video conference was just not as efficient or as practical as it was in the past. And relationships between U.S. prosecutors and foreign prosecutors, I think, fell off a bit just because of the lack of travel. So, but I think we are definitely at the beginning of an upswing, and time will tell if all of the aggressive rhetoric pans out.
Yeah, thanks, Nick. I think that's very consistent with what we are seeing. As a firm, we get involved quite a lot in the calculation of disgorgement or ability to pay calculations. And yeah, we've seen since kind of the end of March, quite a lot of items come to us suggesting that those ongoing investigations that you're alluding to are kind of reaching resolutions. We may see quite a few more come through before the end of September, the government's year end. But maybe, Camilla, turning to yourself, obviously your old employer, the SFO, it's kind of had a bit of an up and down year for them from the UK perspective in terms of how they're bringing cases. Maybe you could give your thoughts as to what we can expect, what we have seen, and what we might think of what's happening at the SFO.
Sure, Neil. I mean, I think generally the UK follows the trends that are set in the US, and in the past I think we've seen cases brought by agencies in the UK that sort of tend to mirror those that we've seen brought in the US. Although I think we have seen a bit of a shift in relation to that when I think about some of the more recent larger enforcement cases such as Rolls-Royce and Airbus, where the SFO was either the lead agency or involved, for example, in the case of Airbus, in a joint investigation team with the French PNF, the French corruption agency. So I think really interesting to look at those two cases as examples of where the DOJ isn't necessarily taking the lead, but others are sort of standing shoulder to shoulder or indeed taking a larger share of the pie. But I think, yes, very much in general terms, trends are set by the US enforcement landscape. The SFO and the FCA, like the DOJ and SEC and other global enforcement agencies, have all had their own challenges during COVID. I'm not sure that the UK authorities fared quite as well as the description that Nick's described in terms of the DOJ and the SEC. I think that they found the operational challenges involved in remote working more difficult and definitely slowed down casework. So things like arrest and search operations were largely on hold for many months on end. And really we're only now seeing them sort of getting going again. And so I think there was very much the impression of those agencies going a little bit quiet during the sort of the peak of the COVID lockdown time. We have, of course, seen the Glencore resolution, and I referenced Petrofac, which obviously FRA were involved in as well at the back end of last year. And I think those are really good examples, particularly Petrofac, of the SFO trying to do what Lisa Sofsky, the current director, talked about right at the start of her directorship, which was, again, trying to emulate the sort of the DOJ approach of flipping a witness. So Petrofac, for example, was an example of an individual who pleaded guilty, and that inevitably put some pressure on the corporate. And again, as I said, you know, the corporate ended up entering a guilty plea in relation to failure to prevent bribery allegations, but on an agreed basis. I think it's really interesting to think about how that compares to sort of the DPA tool and the model where there was a guilty plea, and perhaps we can talk about that later. But yes, the SFO are under particular difficulties at the moment. I think we're all still digesting really the two recent reports that came out at the back end of last year. The back end of last week. So the first of those was the Attorney General's report relating to the SFO's handling of a particular case, Unit Oil, where now 3 out of 4 convictions have been overturned, and there was heavy criticism, both of the director but also others involved at the SFO, and a number of recommendations for improvements in terms of quality and assurance and decision making, particularly in relation to disclosure, and criticism in particular around the handling of a third party sort of non-legal individual. And I think that's undoubtedly a challenge. And I must say, I've got no personal knowledge of that. I've only seen what we've all seen in the public domain. But I think it's fair to say that it's undoubtedly damaging for an organisation to have to come to terms with that sort of a report. That said, the SFO have come out and said that they accept the findings, that there will be immediate implementation of the recommendations, so both the recommendations coming out of that Attorney General's review as well as another internal review that they did. And I guess we wait to see the outcome of that implementation, and certainly I think there will be very close scrutiny of the SFO going forward. The Superintending Office, which is the Attorney General's Department, has said that they were looking and making statements in Parliament at the back end of this year, November, and then again in February. So there will be close scrutiny of the SFO going forward. And I suspect what that translates into is perhaps a renewed effort to bring to a resolution some of these cases that we know have been in the pipeline for some time, particularly some of those cases that have a global element. I think they'll be looking more closely towards their friends in the DOJ and other global agencies to help them and support them through their mission and purpose, because the scrutiny is really on the SFO at the moment.
Yeah, thank you. I mean, the reports, looking at them, a lot of the Attorney General's report seems to focus very much on kind of disclosure and what you disclose to Defence Counsel. But the internal report that you refer to also makes reference to a lack of proper resourcing and outdated technology. Do you think that's an issue that will plague the SFO for some time, to find and recruit, appropriate resources in order to carry out their mission?
I mean, certainly I would have thought, unfortunately, these 2 reviews won't help. It's not going to help that sort of effort. That said, when I was there and the cases that I worked on, and frankly on the other side of Petrofac, there clearly are very talented individuals that are there working conscientiously and doing a good job. But I think retention is an issue. We don't see necessarily the same budget increase or resourcing increase that I know the DOJ are currently blessed with, and I think that is a big question. I think there is a real delta between some of the rhetoric that we see from government and the agencies in terms of the policy behind clamping down on things like kleptocracy and sanctions breaches and legislative changes designed to assist in that, and then the resourcing to enforce that agenda. So I think that's what we're waiting to see is the resourcing coming to fulfil that mandate that we're seeing government policy talk to.
Okay, great. So maybe just looking at some of the areas. I mean, I think obviously, Nick, you paint a picture that the DOJ is ramping up, the SEC is ramping up, new cases are being brought. So maybe we'll talk to the audience about some areas that we might think will be coming. Corruption and the enforcement of the FCPA, the US anti-corruption law, has been a mainstay for the last few years. Do you see that continuing?
Yeah, so corruption continues to be, and I think will in the future be a key area of focus, and that's because it touches so many other things. So right now, among the priorities, certainly you would have to put sanctions enforcement first. Given of all the things the DOJ I think is focused on right now, that is probably at the very top of the list. And when you're in Russian sanctions, of course, in particular, and so corruption is kind of the other side of that coin, and looking at oligarch money and where it is. But there's, among the units at the Department of Justice that are the most sort of developed in terms of internal resources and expertise and coherence is the FCPA unit. And you sort of, no matter what administration you're in, that continues to be a very active, very well resourced, very well led group within the Department of Justice. So I think they will play a key role in enforcing some of the Russian efforts. I think the other things that go along with corruption and sanctions are, of course, money laundering and tax evasion. Those are two areas where U.S. authorities, will continue to focus and have very broad reach. Our, the extraterritorial reach of the FCPA is, of course, world famous, but also our money laundering laws are very broad and can, reach conduct far outside the shores. Kind of a little closer to home, ESG is a very high area of focus right now, particularly in terms of environmental disclosures, both on the part of issuers in what they say about their own businesses, and perhaps even more on the part of investment management firms who create, funds that are supposed to be ESG friendly. There was a task force formed by the SEC in March of last year to focus on ESG enforcement. We didn't see much for, publicly, although, those of us who practice in this area know that there are quite a few ESG focused investigations, but we're now starting to see that I think the fruits of that work. There was a recent settlement with Bank of New York, one involving GWS, a Deutsche Bank subsidiary, and I think it's clear there's going to be more to come there too.
Yeah, well, thank you very much, Nick. Yeah, Camilla, you were obviously part of the anti-corruption group while at the SFO. Do you see the UK and other regulators in Europe continuing to focus on corruption efforts?
Yeah, I think the picture is very similar to that Nick outlined for the US in terms of priorities. I think definitely sanctions, so corruption, yes, but I think sanctions also definitely moved up the agenda and is very much likely to be a focus of the UK authorities in the future. February of this year, we have a new body within the National Crime Agency. It's called Combating Kleptocracy Cell. It's a dedicated group that's designed to look at sanctions evasions and money laundering. And recently we've seen the NCA arrest some 10 individuals who they've described as enablers, including attorneys, those supporting, as it's described by the NCA, corrupt elites to evade sanctions. So very much a focus on that in terms of what we're seeing in sort of in the future. But corruption is still an important agenda item because, as Nick says, they're two sides of the same coin. ESG as well, you know, we work in a global market, so the issues in relation to ESG are touching us in the UK and Europe as they are in the US. I think what's really interesting though is that what we're seeing is a sort of a bit of a regulatory copycat trend. So we've seen the sort of the US regulator flap its wings, and then the world sort of seems to listen. So we're seeing sort of clients which are, you know, dual or multi-regulated, having a non-US regulator pick up the baton that may have been started in the US and asking questions. At the moment, they're supervisory, but around systems and controls and products. And that's quite a challenge for these corporates, particularly where you've got jurisdictional variation across regulators on ESG requirements. So, for example, in prospectus disclosures. So we are seeing more momentum in terms of ESG. We're not seeing necessarily enforcement action, but we're certainly seeing more interest and more activity. And I think that means we're seeing more internal investigation. So we're seeing clients wanting to get ahead of the game, understanding their exposure, looking again at their compliance and risk exposure.
Yeah, no, thank you. I think, as you say, there's been some interesting statements, certainly around the sanctions and the priority that you both refer to. I know that Deputy Attorney General in the US, Lisa Monaco, last week actually said that US sanction enforcement will be the new FCPA, and we all know just how prevalent that has been over several years. So I think picking up maybe a couple of her comments that I thought were very interesting is that in their mind, it's no longer is it a concern for banks and financial institutions, and they're also wanting to look at anyone who has an international supply chain needs to be prepared to actually have a compliance program that is robust. And within her speech that was made in front of the New York City Bar Association, I understand she made several recommendations that companies need to follow, and perhaps we can touch upon some of those later. But I thought it was interesting, kind of the shift away from the financial institutions. And Camilla, I think in the arrests that you referred to that were announced this week, of the 10 individuals, I think they also kind of put auction houses, I believe, as an area that they're also going to focus in on, as well as private schools. So it looks as if the UK were looking again much broader than some of those particular areas.
Neil, I
yes,
would add
please.
one other point on the sanctions, which is we all know and has gone well remarked how cooperation has improved over the last 5 or 10 years between the United States and a number of other foreign jurisdictions. We have never seen cooperation like we see now in the sanction space when it comes to tracing assets of Russians subject to the Russian sanctions. I mean, it's almost instantaneous when the U.S. is picking up the phone, places in Europe, Switzerland, the UK, the information sharing is happening so quickly, and the US and the other countries have been able to move incredibly fast on asset seizures. It really is sort of remarkable, and I think it's something that is likely to, over time spill over into other areas too.
Yeah, thanks. And with those asset seizures, are you seeing courts in foreign jurisdictions also basically acting upon judgments made, say in the US or the UK, to seize a particular asset? Are they actually honouring those? Because that's been an issue in the past for those involved in asset tracing.
Yeah, I think it's complicated. I think in the examples we've seen so far, what we're seeing is sort of parallel judgments or parallel orders in different countries to try to affect that. It's been very, we've seen with some yachts that have been seized. It's very well coordinated. But you're right. It's when it's only one country acting, it can be a challenge to enforce those orders elsewhere. But when you have the will of all of the countries where the assets are being held, it's remarkably different.
Yeah, I think that's it's interesting, the comment about this international cooperation, because I think in the same speech I referred to that Lisa Monaco provided, she said that the FCPA for 10 years was almost dormant because they didn't have, it was the US kind of going it alone. But to your point, it seems as if the infrastructure to doing international investigations that sanctions involve, there is the infrastructure there now and the coordination between regulators. And so any ramp up should not take the same kind of length of time that we saw with the FCPA. I mean, Camilla, obviously you were in part of SO for a while. How do you view the international cooperation? Do you agree with Nick that it's the best almost it's ever been?
Yeah, I think so. And I think some of that is because individual jurisdictions are ramping up themselves. So whether it's Australia, who are looking to pass their own sort of DPA tool, or obviously France a couple of years ago now, or 3 years ago with Sapender. So it's individual jurisdictions deciding to police their own, but the benefit in terms of law enforcement is that there are then stronger partners for the likes of the DOJ to work with, as opposed to simply take along with them, but they have the resourcing and the abilities themselves to investigate and assist. And I think that's what we're seeing more of, that these agencies themselves have the capacity. And I think something like the PNF, which is fairly newly established, succeeding in a case such as Airbus is a really good example of that, where you've got more established partners such as the SFO and the DOJ working alongside them. There's a lot of learning, and not just learning sort of operationally, but also intellectually in terms of how do you use a new policy tool like a DPA. And as you say, so those structures are then there, that learning is then there, and it can be translated into other fields, as we're seeing now, I think, in the sanctions world.
Great. Yep. I mean, just talking about that cooperation and looking at a comment that Nick shared about industry level sweeps that we may see coming back and other areas of focus. I mean, we've seen quite a lot in the corruption realm of kind of some of the cleanup work that's been done in South Africa. I'm not sure if either of you are involved in some of the kind of what's coming out of the Zondo Commission report, kind of looking at the corruption under the prior president Zuma and some of his friends, the Gupta family being named. But we're seeing quite a lot of cooperation there, but not only the enforcement agencies, but also development banks who may have provided funding for some of these projects that happened in Africa. So it seems as if it goes beyond purely SFO, DOJ, but also into those who are actually extending finance to these organizations. But in terms of industry type sweeps, Nick, you mentioned that you can see that there might be returning to that we saw under President Obama's administration. Are you seeing anything from clients reaching out to you just now that might suggest that there's a particular industry or jurisdiction that's under in the crosshairs?
Well, the financial institutions continue to always be, a juicy target for enforcers. Most recently, a couple of big areas where we've seen very active sweeps. One is to do with the use of personal devices among traders, and whether by texting and using other ephemeral communication platforms, traders are violating the rules about maintaining business records and customer communications. We've seen a couple of settlements come out, and I think has been written publicly, there are lots of other banks that are in the pipeline for similar outcomes. Market manipulation continues to be an area of high focus. That's not new. It's a continuation of a trend that started maybe 5 years ago, maybe even a bit more than that. Spoofing in particular, which was made a crime under the Dodd-Frank Act, has been very vigorously enforced by the unit at the Department of Justice in Washington, at Main Justice, that's focused on trading activities and market manipulation type activities. There's a trial going on right now in Chicago involving former traders of JP Morgan in a spoofing case in which JP Morgan resolved through a deferred prosecution agreement based on the activities of these traders. So, the financial firms are always going to, I think, be ripe for investigations like this, industry investigations. The other area where we're seeing it is in the big tech firms, for political reasons. They've come under a lot of scrutiny in the areas of privacy and the maintenance of customer information, as well as First Amendment freedom of speech type activities. So far, I think those haven't gotten the type of sustained federal Department of Justice focus as the financial institutions. It's been a bit more localized in state prosecutors' offices, perhaps for political reasons. But those, I think, are areas that have become, where everyone in the industry is grappling with the same type of issues.
Okay. No, thank you both. Perhaps we can move on to kind of our next area. I think we've said that there's been several quite loud pronouncements, kind of both sides of the Atlantic. Some of those have related in kind of new laws being passed, certainly in the UK, and other potential changes that might be forthcoming. Maybe, Camilla, I can start with you. There's been quite a lot of kind of announcements made within the UK regarding how that jurisdiction will actually prosecute securities fraud and other forms of fraud.
Yeah, so you're right there, Neil. So we had the Economic Crime Act, which was passed earlier this year. Really interestingly, it was actually going to be shelved by Parliament, and then it was really put back onto the statute book as a result of the Ukraine war. And it was described by certainly some parliamentarians as being the UK's response to the Ukraine war, which I think is a really interesting way of looking at the fight against financial crime. And I think perhaps the sort of three areas to sort of talk about are the sanctions piece. So under the Act, there is now a civil penalty. There's a strict liability, for civil liability for a breach of a financial sanction, which is basically bringing the UK in line with the US. And it's a really important change, I think, because in terms of the strict liability, the test is now where a person knew or had reasonable cause to believe that they were in breach. So in other words, the relevant entity will need to be very mindful of the risk of breaching a sanction and need to be very careful in terms of decision making and recording of those decisions, because I think we are likely to see enforcement in this area. That's why it's been brought in, to make it easier for OSCE, the sanctions regulator in the UK, to bring enforcement action and to bring fines against corporates who aren't being careful enough about the risk of sanctions breaches. We also see in that Act a beefing up of the unexplained wealth orders. So that was very much a tool that was meant to assist investigators, but has really been underutilized. It allows investigators to confiscate criminal assets without having to prove to a criminal standard of proof how that property was obtained. But it's been difficult to use. So this new piece of legislation is designed to make it easier for investigators, give them more time, expands the definition of property under an unexplained wealth order. And also the law enforcement agencies are protected in terms of claims of costs if their attempts to secure a UWO fail, and we've seen some fail in the past. But the reality is that it's still going to be a challenge for law enforcement to use, because where the target of a UWO is able to put forward a challenge, then there will still need to be a detailed investigation by law enforcement, which is going to be time consuming and costly. So it'll be really interesting to see what changes it actually brings about. We've also seen more recently the Law Commission report, a report that came out in June this year, a long-awaited report, some 2 years in the making, looking at the options that the UK want to consider in terms of reforming corporate criminal prosecutions. I think that's a really interesting report that's come out. I think there's a lot of noise and from governments in relation to it. There are 10 different options that the Law Commission has provided to government in terms of future amendments to legislation that it might want to put into force. And it looks at the issue of identification doctrine, the failure to prevent model, as well as providing for companies to put out positive information about their anti-fraud procedures. And I think whatever the government decides to do in relation to these 10 options, it is going to have a significant impact on the companies that are affected. And I think it will depend what sector you're in. I mean, if you're in the regulated sector, there's already a lot of regulation around this. But so it depends which sector you're in, the impact may be greater. But I think if we look back to the Bribery Act, which is now over 10 years old, and the failure to prevent model that was brought in through that act, there's really a whole-scale change in corporate culture as a result. I don't think we'll see quite that level of change, but we will see, I think, really substantial implications for corporates, because any form of a failure to prevent offence could dramatically expand the scope of the policies and controls that a company needs to have and needs to be able to show that it has in place. But it'd be really interesting to see which of those 10 options the government goes for. So the next step is for the government to review the options paper and then to make its paper and put it to Parliament. But I think we're likely to see some action from the government here. Exactly what, it'll be really interesting to see. If you were to virtually twist my arm, Neil, and ask me for a prediction, I think I would say we're likely to see a failure to prevent human rights abuses as the expansion. We've seen a lot of focus on modern slavery in the last few years, and I think we're going to see that. I think that's a real area of focus for the government, and it'll likely just be an extension of some of the legislative change that we've already seen. The Modern Slavery Act came in 2015.
Yeah, and this failure to prevent, I noticed that there was a case that we were talking about and preparing for this in the corruption realm, that the Metropolitan Police Service actually took a case. So there is precedent in the UK for actually taking a case alleging that companies failed to prevent, in this case, corruption.
Yeah, I mean, I think that was the first case that the police had brought as against a corporate for a failure to prevent a bribery offence. So it is interesting to see that there are other agencies other than the SFO that are bringing these failure to prevent cases. So yes, it would be really interesting to see whether there is that failure to prevent model expanded out from where it already exists, which is in the bribery and corruption space and also in the facilitation of tax evasion space.
Lots of implications for companies. And talking of implications, Nick, you've referenced already some changes that the Biden administration is kind of bringing back, changes that the Trump administration made. And there's Lisa Monaco, the Deputy Attorney General, made some pretty broad statements that maybe you can tell the audience about.
Yeah, sure. Nothing nearly as dramatic as what Camilla has described in the UK. It's been sort of a return to old policies in many ways. And some of these changes are, you know, in hindsight, I think will seem rather subtle. But starting with a memo from Sally Yates during the Obama administration, which the focus of which was re-emphasizing individual accountability. So prosecutions of real persons rather than just, having companies pay giant fines while nobody actually, goes to jail. The famous, Yates memo made very clear that for a company to earn any cooperation credit at all, it needed to provide, all information about that it had in its possession about all, relevant individuals and their conduct. That was dialed back somewhat under the DOJ and the Trump administration. The limit of the disclosures was actually described as being, only as to individuals that are substantially involved in the misconduct. And I think that was meant to address a concern that the Yates memo was essentially requiring companies to sort of boil the ocean, and it was causing investigations to last years beyond where they really needed to try to find every piece of evidence that existed against, every employee, who, regardless of how attenuated his or her involvement may have been. Very soon under Lisa Monaco, it was announced that they were going back to the prior wording, which is, all means all. I'll be honest, I'm not sure how much in practice that will really change things, but there may be cases out on the margins that where the resolution gets prolonged because there are sort of so many people involved and it takes a longer time to collect the information. So that's the first one. I think it's more important tonally perhaps than it is semantically, and that it's kind of reconfirming the DOJ's focus on prosecuting individuals and not simply big companies. The other change, which I think is likely to be more significant, is on prior misconduct. One of the very important factors that the DOJ considers under the policies that guide federal prosecutors in the prosecution of business organizations is what is the criminal history of the company? Is the company a, quote, recidivist? And, up until now, the guidance read that you would look to see if the company had a prior investigation resolution, in the same or a related area. The DOJ has now said, we're going to look at all prior resolutions. So even if it's not exactly for the same type of activity, we will still hold that against the company if they have had other, criminal or regulatory resolutions. And that's a really tough standard when you think about, major international companies that are in all different businesses in all different parts of the world. I personally have a tough time with the concept of recidivism for a corporate entity where the constituencies change so much over time. And if a bank settled a LIBOR investigation in 2011 involving its trading desk in London, and 11 years later you have a new CEO, a new board of directors, entirely new management, and it has investigation, let's say, involving AML in Latin America. I mean, can you really say that that company is a recidivist and has not sort of learned its lesson from the prior settlement? So I think companies immediately upon this change in the policy expressed great concern that there is no large company in the world, certainly no large financial institution, that if you go back far enough, you can't find a series of resolutions, many of which are criminal in nature. And the question I think was fairly raised: does that mean that every company is going to be treated as a recidivist, and deferred prosecution or non-prosecution agreements are going to be off the table for all future violations? I think the DOJ, more privately than publicly, I think has tried to give assurances that there will be kind of a reasonableness test here. So if something is so old or so unrelated, that it's not going to carry very much weight in terms of future resolutions. So I think there's some reason to hope that this policy will not be quite as draconian as it could be if you were to read it literally. And then the final change I think I'll note and again is likely to be significant, is corporate monitors. The Trump administration tried to dial back the frequency with which monitors are imposed as part of DOJ resolutions, and it issued a memorandum saying that monitors would be the exception and not the rule, and would have to only be in cases where there's a clear need for it. The DOJ under Biden immediately walked that back to, and so I think, you know, and recent resolutions have shown this. I think we're going to see that it's probably more common than not in every case, but I think in the majority of cases, you're going to see some sort of corporate monitor, or if not, you know, an independent compliance consultant attached to criminal resolutions. And, you know, we know that that's a big deal for companies. Those monitorships tend to be both expensive, but more than just the money, very time consuming in terms of management attention. So I think that will be significant, and it's something to keep an eye on going forward.
Yeah, no, big changes potentially coming based upon those statements. As you say, we're still to see it, but I'm sure in the coming months we'll get a feel for just how they're interpreting those. Camilla, can I ask you just on the last point on corporate monitorships? What do you think is the appetite in Europe to actually appoint a corporate compliance monitor? Is that something that you think we can expect to see in resolutions brought by the SFO and other regulators in Europe?
Yeah, I think it's a really interesting one, Neil, because I think in general terms, the UK and the US are aligned in terms of expectations of a compliance policy and remediation. So I know, for example, the SFO and the DOJ did joint training in relation to expectations of a compliance program. And yet, I don't think we're going to see the use of a monitor in the same way by the SFO. And I think that's in part because corporates are so keen, as Nick points out, because of the impact on them, but are so keen to try and get ahead of the curve. And so what we've seen in sort of recent examples, such as the Serco case, is where the company in effect agreed with the SFO, a third-party reviewer. So not the same legal obligations as a monitor, but an independent review of its compliance program and remediation. And we saw the same sort of model used on Airbus and Rolls-Royce, where the corporate sort of tries to get ahead of the game, so puts in place a, in effect, sort of reviewer monitor, but does that before law enforcement gets involved. And I think they were helped in that regard by the length of time it takes to get to a resolution. So at the sort of the start of an internal investigation phase, bringing in somebody to assist with the compliance program and the remediation, looking at what's gone wrong, and doing that in parallel with the investigation, both from the regulator or prosecutor, but also internally, I think has helped some corporates to avoid the risk of a monitor. So it's on the agenda for the SFO, but I think we're yet to see it, and I'm not clear that we're going to necessarily see that in the future, because I think corporates are so keen to avoid it where they can.
Yeah, no, thank you for that. It'll be interesting to see what kind of comes out of it. Just before we move on to the final section, just to kind of reference a couple of other areas here. You know, there's been lots of rhetoric around the role of gatekeepers, and I know that within the UK there's been quite a lot of focus on the role of the auditors and external auditors following some pretty high-profile kind of accounting scandals, whether it be the Carillion case, which went into bankruptcy. I think we've had BHS, high street chain that went under, and more recently there's the NMC Health and Finabler that went under. So I think that you know, for about a couple of years there's been this plan in place to replace the Financial Reporting Council in the UK with the Audit, Reporting and Good Governance Authority. And I think the FRC came out with a 3-year plan as to how they would do this. I think that plan calls for a variety of different measures, including kind of stopping the dominance of the Big Four from auditing, kind of spreading the wealth around. Also interesting for corporates, It's basically placing more accountability on corporate directors at the board level for making sure they're looking at fraud risks and as the company taking steps to address those. Then finally, I think there was talk as well of proposing more of a Sarbanes-Oxley 404 sort of framework where there's going to be more internal controls and internal control reporting. But we do think that that this is something which is interesting development. Obviously, the US or the PCAOB have gone through this, and we have seen some pretty large fines, not least of which in the last week, comparing a $100 million fine issued by the SEC against an auditing firm for kind of cheating some of the AICPA results. But we have seen some other fines come out recently in the UK, albeit smaller monetary amounts, I think 2 million for one of the audits of Sport Direct. So I think that's another kind of area that corporates will have to deal with in terms of how they interact with their auditors, because greater emphasis on auditors kind of being part of the gatekeeping solution. So maybe we can move on. I've got 10 minutes left. Maybe move on to kind of discussion a little bit around. So what does this mean? We've heard obviously what the enforcement agencies have worked on now, what we think may be coming in the future. So you both advise your clients day in, day out. So maybe starting with you, Nick. This whole concept of it's an international enforcement, whether it be sanctions, corruption, or others. What is the real challenge that a company operating internationally must face?
Well, I mean, there are so many, but I putting aside sort of the obvious ones of jurisdictions and trying to get data out of certain locations, which could be a topic for its own webinar. But I think under the current DOJ regime, clients are legitimately asking. I mean, look, we have a whole series of prior resolutions. Based on what they're telling us, we have no chance of getting a deferred prosecution agreement or a non-prosecution agreement. So what is the point? Like, why, if self-reporting and cooperation, are not going to have any real impact on the outcome, or really can't change the form of the resolution under the DOJ's policy about recidivism, then what's sort of in it for us? Now, I don't, most highly regulated institutions might think that, and yet still, know that their only option really is to self-report and cooperate. But I think in areas that are less regulated, I think companies are really going to take a hard look and say, what are the chances that there'll be a whistleblower, someone else will report this issue to the government, given how hard it is now, how much is required to get cooperation credit in the United States. Is it really in our best interest to pick up the phone and make a self-report? In my experience, there aren't a lot of cases where clients make that judgment and decide not to self-report, but there certainly are going to be some, and it'll be interesting to see just how profound I think that impact is.
Camilla, maybe just following up on Nick's comment about how do you self-report or make the decision. We talked at the start of the webinar about kind of the SFO's kind of issues right now, dealing with some internal, and does that also factor into whether you self-report or not? Do you see a decrease perhaps in the number of companies willing to self-report?
Yeah, I mean, I think very much the same issues that Nick highlighted exist in terms of reporting to the SFO. I think also if you're a global corporate, you're not necessarily going to be just reporting to one agency. So you're going to have to think long and hard about your exposure in the different jurisdictions that you operate in, and I think that's the big challenge. So although you might think for the time being that the SFO is less of a concern, if you've got any risk in terms of the FCPA, you're also going to need to consider your risk there and whether that will force you to walk through the door of the SFO at the same time. I mean, that said, as I sort of mentioned, that the Petrofac case that me and my team worked on, I think is a really interesting example of a guilty plea that was agreed with the SFO. So there's a process of plea discussions, and ultimately I think something that's perceived to be, you know, a successful outcome for Petrofac, and particularly in relation to their refinancing issues. So I think there are real questions about the benefits of a DPA versus a guilty plea, and questions over self-reporting or not. And I think obviously it all depends on the individual case and the individual exposure, but I think it is, as ever, a difficult decision to be made, and one that needs to be really carefully thought through.
And the added complication, I guess, Nick, based on the Lisa Monaco's statements about, you know, assume that you will get a corporate monitor rather than the converse of it's the exception. I mean, as you've said before, I mean, that's a very time-consuming commitment that a company has to go through. It's quite intrusive. It gets into the nitty-gritty of the company. So, in terms of what a company can do to try to avoid that, do you think there are ways that a company can successfully negotiate with the DOJ that they should not be subject to a monitor?
I think so. I think the bar has gotten higher, but it doesn't mean that every case will have a monitor. I think what you can do, and probably the best thing you can do, is to try to remediate as much as you can before you're even sitting down with the government to talk about resolution. And that can be hard, and clients can sometimes be reluctant to do that because they think, if I start changing things, fixing things, isn't that going to be viewed as an admission that they were broken to begin with? And you know, and you can understand intuitively that feeling, but I think most of the time that instinct should be resisted, because you know, if you're in an investigation and you might one day soon be talking about a resolution, then even if things worked, surely they could have worked better, and there can be improvements. And I think regulators, particularly financial regulators, really are looking that when companies go through an experience like an investigation, that there are lessons that they learn from it and that they can make improvements. There's no compliance program that's so great that it can't be enhanced somehow. And so I think if you can sit down with a government agency and say, here are all the things we do better than when this conduct occurred, and here's why we're confident it wouldn't happen again, or at least, you know, it wouldn't happen this way, we would have detected it more quickly. I think that really puts you in the best possible posture to try to convince the government that the changes have already happened, and a monitor is not necessary to make the company fix what was broken.
Okay. And we've seen quite a lot of guidance put out, certainly in the US, regarding what they view as a strong compliance program. There was the corporate compliance programs issued by the DOJ, and we've talked a lot about sanctions. I think OFAC also put out a compliance framework guide. Camilla, from being in-house, do you believe that the regulators are now more in tune with what a good compliance program looks like, so that they have the tools necessary to evaluate them to a strong degree?
I think so. I think there's been a lot of learning, certainly in the UK, in terms of, you know, what the regulators and prosecutors expect. So I think they are now up to speed in general terms. I think, as ever, they focus on the sort of a risk-based approach, whereas I think more sophisticated corporates are now looking from an ethics, behavioural approach in terms of prevention of financial crime risk. But in terms of the assessment of a compliance program, I think they're in a better shape than they ever have been. I guess that's probably the sort of the fairest way of putting it.
Okay. No, that's great. I think we're pretty much at the top of the hour now, so being respectful of people's time. I just want to take the opportunity to thank Mondak for kind of hosting this. Big thank you to Camilla for joining us in the UK, is getting into her evening. And Nick, thank you very much for joining. I know you joined us last minute as one of your colleagues had an emergency to take care of. So appreciate all of the great comments. I hope that everyone enjoyed. We look forward to your feedback. Look forward to joining you on a future webinar. Thank you very much, everyone.
Thank you.
Thanks. Bye.